on ABC Melbourne. Patricia Carvelis with you, filling in for Jon Faine and David Whiting. He's a solicitor. He takes your talkback, 1300 222 774, 1300 222 774 for all your legal calls. Get them in. David, welcome.
Thank you, Patricia.
Any homework from last week?
I did. I had a man from Moe who rang because the council had asked him to repair the crossing. And a vehicular crossing it's from the road pavement to your property, and his was all broken and council wanted him to fix it. Now, there is a local law that says you must fix, so you can be called upon to fix a broken crossing, but you can't be called up. It doesn't say you can go on and be called on to fix any other footpath in front of your property, just that one. He had an interesting argument that his footpath was slightly offset from the rollover at the curb, but there is a local law. There is an argument that council should not be able to require you to do any work outside your property.
Yeah.
For example, some councils have bylaws that require you to maintain your nature strip. And there's an interesting question about whether or not they could tell you that you can't use the nature strip other than so you can't plant, etc. But there's an interesting question as to whether they should be make you do it, and the answer would... I look at it on the basis that it's going to cost you quite a few $1,000s to run the matter in the Supreme Court, that it's beyond power. Better that you fix it, and the advice that I would give to Ted from Moe is that he has an obligation under the local law to attend. If he wants to spend 5 or 6 times the cost of fixing the footpath...
so he should grin and bear it.
He should grin and bear it, and it would be significantly cheaper for him to do so. But I would also then go and get a crossing permit to make sure that your crossing is in the right point, at which point you may have less issues with the breakup of your footpath. And beyond that, a glorious case that was reported in the Eastern Suburbs newspapers and in this morning's Herald Sun, but more information in the Eastern Suburbs. A man parks a 6-tonne vehicle in a disabled spot with a disabled sticker on it, and he gets a ticket from the council for breaching a rule that says the driver of a heavy vehicle must not stop on a length of road in a built-up area for longer than an hour unless permitted to do so. And so, while that matter could properly run in the Magistrates Court if you disputed the ticket, he decided that he would run it in the Supreme Court. And in running the Supreme Court, he ran the argument that there is a road rule which says that if you've got a disabled sticker, then those provisions don't apply to you in the same way. He was totally unsuccessful, having managed to run it before an Associate Justice and a judge in the Supreme Court. And what I found interesting was that it cost the council $43,000 to have the argument that they won convincingly. And it will be interesting to see what level of costs they might recover. $43,000, yes, to defend themselves against a self-represented litigant. And I learnt 2 other things from looking at that. The first is that if an authorised officer of council asks you for your name and address and you don't provide it, you can be taken to court and fined up to $9,000.
Really?
Yes.
I didn't know that.
No, well, I didn't either until this morning. But $9,000, 60 penalty units is about $150 a penalty unit.
Really?
It's an extraordinary amount of money.
An authorised council officer can ask you for your name and you must provide it.
What the Section 224 of the Local Government Act
It's a very little known part of the Act, though, isn't it?
Well, it's one of those ones that hopefully we never need to refer to again. And the other thing I learnt was that the disabled stickers are technically only valid in the area in which the council issues them. So if you were in Frankston and you had a council permit issued by council, then that's where it works. So there will be perhaps one ought to look and see whether we mightn't change the road laws to make sure it's issued by a council rather than the council.
A council, the council.
Yes. So that's that one. And a great story out of the UK in relation to computer-generated letters. In the UK, you can borrow money from PayPal. So in the UK, a lady owed them £3,000 and died, and her husband wrote to them and said, look, she's died. So instead of writing to the executor and saying, look, thank you very much, this is the amount we seek to recover, they wrote to her. Well, put her name on the letter, I suppose, a better way to describe it. You're in breach of condition 15.4C with your agreement with PayPal Credit. We have received notification that you are deceased and this breach is not capable of remedy. So, it would be nice to put a little bit more thought into the letter.
Who is responsible for that
it depends on the
level
button
of
you press on the
stupidity?
computer, isn't it?
Well, someone at some point generated this.
Yes.
At some point, there was a human involved, right?
There has been but at what point? There has been an apology issued by PayPal in the UK, but and I haven't looked at the Australian document, but the US document says that if you pass away while owing PayPal credit money, that also constitutes a breach.
Incredible stuff. What a letter to receive. Sue from Mont Albert is calling. Not Mont Albert North, I should say. Sue, welcome.
Thank you.
What's your
Hello,
question?
Sue.
Hi. Yes, look, my partner's going through settlement with his ex-wife at the moment, who he divorced 3 months ago. And basically she wants half of his superannuation, although she moved away from the family home 10 years ago and lived with another man.
Yes, so and did he have any superannuation when she left 10 years ago?
Yes.
So what she's doing is she's coming along and saying, well, I want a share of the matrimonial asset pool that existed when the marriage came to an end.
That's right, yes. She's saying basically from when they divorced 3 months ago, she wants superannuation and half property, etc., as from 3 months ago, just prior to the 3 months ago.
Well, Sue, I haven't heard her side. I don't know the answer. But if you think about it, 10 years ago, property values have probably doubled.
Yes.
So there would have been a return on the superannuation fund between the time the marriage ended and ignoring his extra contributions and the returns on those. Mm-hmm. So it would be possible to calculate what I'll call the present value of the superannuation based on the contribution level at the time when they separated.
Yep.
So that's in a sense. This, in a sense, is the problem. Everyone expects that people will be entirely rational and make a whole series of reasonable requests. It doesn't happen that way. You start with an ambit claim and you get beaten down. It's the way it works.
Well, especially the fact that she moved away 10 years ago, but she's it's really complicated. She's actually denying that they were really separated, even though she was living away from the home.
Okay, so then that's part of the argument then.
Yes.
All right, so she's saying your partner's saying 10 years separation.
Yes.
And she's saying no.
That's right.
She's saying 15 months really, 12 months and then the divorce.
Yes.
So that's a factual issue. The problem that I have, Sue, is that he could end up spending an absolute fortune at a point that just exceeds the value that he's going to get out of the argument.
Okay.
I think the answer is you look at it from the way. So try and measure what you say the asset pool was at the time the relationship came to an end, and then move forward from that.
Yep.
Right. So let's say it was $50,000 in super 10 years ago.
Yes.
The superannuation fund will be able to tell you what returns they've achieved on the fund in that time.
Yes.
And if it's the same property that we had 10 years ago and we've got today, then that's the argument that you run there, is you say, well, if it's... And what we're really looking, however, is how much did he contribute to pay off the mortgage in that time?
Yes, I think they were both contributing. So.
Okay, right. So it might well be that the real issue, because in a sense he's paid some expenses in relation to the property, she has too, then you get this really interesting question of what's the value of the contribution given that he wouldn't have paid rent?
Yes.
Yeah.
Yeah, so that's a point too.
So I say, if you say that separation was 10 years ago, then the question is, what was the matrimonial property at the point they separated? What did they each own at that point of time? And then try and get some advice as to how reasonable her actual claim is.
Yep.
All right.
Does that answer it
All
for
right.
you? Thank you.
Yes,
Thank you,
Sue.
Sue.
Jenny from Point Cook calling in. Hello, Jenny.
Oh, hi, David. Patricia, I'm calling on my brother's behalf. His wife basically left him with my sister 2 years ago because he had a brain tumour, and they hadn't, when they separated, made out wills.
Yes.
Since then, about 6 months into living with my sister, he made a will leaving his home to my nephew, who'd lived there since 1997.
Yes.
Now, our worry is, would his ex, when he passes, have a claim against his house, even though she has her own property that they had lived in?
The short answer is yes.
Right,
That's not the same as she would succeed in an application.
right.
And are they still married?
Well, she's told everyone they're separated, but legally they're still married.
Then the answer is that the legislation gives her the right to make a claim
Right,
because of the marriage.
right.
If he was to have a property settlement with her, that would go away at that point.
Right.
Does that help?
Well, we're worried that she's going to try and take the house off my nephew.
Well, she's eligible to make a claim.
Right,
I think, and I can't tell you whether she'd succeed or she wouldn't.
right.
You've actually got to work out, as we spoke to Sue before, what was the pool?
The pool was that she had her house for her kids. My brother had his house for his son.
And they were second marriages for both of them. It was a second marriage for both of them?
Yes, that's right.
And did they make wills that said that?
No, because she couldn't agree on who would get what, so they never made a will.
Okay, so it may be that they didn't in fact agree that my house goes to my kids and your house goes to yours.
No, well, at one point I know she wanted his house sold so that she could buy a family property down at Port Arlington as a holiday place.
It's a nice place to have a holiday.
Sounds fantastic.
Jenny, the answer would be just make the will have your brother make the will the way he wants it.
Yeah, well, he made the will about 18 months ago because he couldn't.
Fine, and then that's fine.
Mm.
And what you're going to deal with the issue when it arises, because there's nothing you can do now.
Right. Okay.
And if there's no financial intermingling, there's no reliance.
No,
her ability to make a claim is not great.
Oh, marvellous.
All right,
Jenny.
That's her main worry.
Thanks so much for your call.
Thank you very much.
Okay, and we've got Motty. Hello.
Hi.
You've got an employment issue.
Yeah, it is.
What is
How
it?
are you?
How can we help
Yes.
you, Monty?
Yes, hi. I was working as a structural engineer in an engineering company here in Melbourne.
Yes.
After 2 years, I've got ongoing injury to my hands. I issued a claim to WorkSafe. During all this period, I was prescribed to be at home. After the claim was accepted, the employer decided to dismiss me
Yes.
from my workplace.
Yep.
And since then, I'm trying to find a way to settle this matter. I went to the Fair Work Commission.
Yep.
We had a conference. We haven't got any settlement there.
Yes.
And now the next stage is to go to court.
Yep.
The thing is, to go to court in order to protect my rights, I need to spend between $50,000 to $100,000.
Wow. Yep.
Yeah, this is what I was told by a few different lawyers.
Yes.
Yes. I try to get free legal advice, but I'm probably not too poor to be.
You're not poor
eligible
enough to
for
get
that.
legal aid yet.
Yes.
Yes.
Yes, exactly. Then I thought maybe you have some idea for me.
Well, I do know that it is possible to terminate employment of an employee who's on a work cover claim. All right? There are always questions asked when you do it in those circumstances. So if you terminate an employee who's off on work cover, then yep, there are lots of questions, but it's still possible to do. So you have what I would have thought would be a fairly difficult burden. You've got to prove that your termination, that the principal cause of your termination was your work cover claim.
Yeah,
Are you able to do that?
Yes, of course, because I've got 2 times pay rise from the employer. I've got 3 references from the employer.
No, it's not a question of your quality of your role. It's not that at all.
Yep.
But it would be possible for someone to redesign or reconstruct the department in which you worked, in fact, to make your position disappear. So that would be grounds for, in a sense, here's a redundancy payment. Your position has come to an end. I'm giving you notice. There ought to be discussions, but whether they will allow you large amounts of damages, I wouldn't have thought they would.
Yeah, that's right.
So I'd be going to talk to a firm who would do it on a no-win, no-fee basis, because they'll give you a very blunt assessment of your prospects of success.
All right, Motti, thank you for your call. Rick, you've got a driving conviction or a question around a driving conviction. Hello.
Hi, how are you?
Good.
I went to court the other day for a driving conviction, but I was not the driver at the time, and I'm pretty sure that my plates were copied.
Yes.
What I'm really asking is that I rang up some lawyers, and they told me it's going to be $6,000 to $10,000 to represent me in court, which I don't have. And just wondering, is there any other ways I can get a lawyer to represent me? Is there any lawyers that are pay as you go, or any other legal way I can get a lawyer to represent me?
I suppose the real answer is that what you're looking at is, so you're going to file a defence, or not file a defence, you're going to dispute the matter.
Yes.
Was it the same colour car, make and colour of car that had the plates on it?
You cannot see the car. It was at night. All you could see is the plate.
But presumably there's a shadow which would enable you to get the shape of the car?
Nothing.
And
you might be able to see the lights a little bit, but yeah, it was a very bad photo.
And are you able to prove you were somewhere else?
I was at my sister's house, and
Yes.
she can come into court and say that.
Right. It's kind of sorry. I was going to argue about the colour and make of the car, but that
if it
doesn't
can't
help
be
if you
seen at
can't
all.
see it.
Nothing.
Did you use and this is a driver offence, not an owner offence?
No, because the
Because
car belongs to my girlfriend, and I was driving the car at the time.
Well, your argument was you weren't driving the car. You were driving
You're
your
saying
car.
that the plates had
Yes.
been taken and put on another car.
Or copied, yes.
Yeah, copied. So I had possession of the car at the time,
Yes.
but I was not in the area at all. I was 2 separate sides of Melbourne.
Right, and does your sister live near a shopping strip or something like that? Is there any way we can prove where your car was at the time?
Not really. She actually lives out in rural Mernda way.
Yes, okay.
Yeah, so I'm not sure about I didn't visit any shopping centres or anything like that.
Right.
Only going home.
Yep.
And that was 2 hours after the offence.
And it would have been time for you to get from wherever the offence occurred out there and back again?
Yeah.
All right. Did you use your mobile phone?
Most likely.
Well, why not
Get the
check your
records for the
telephone
time.
records, right?
That's a good idea.
And there's a court case running in the Supreme Court at the moment where we know that a particular mobile phone was pinged by a tower at a particular time.
Yeah.
So what? I'm just simply suggesting that if you've got what
Go
you
to the
consider
mobile
to be...
provider and get the call log for that time.
If you can prove that you've got what I'll call gilt-edged evidence that says it couldn't possibly have been me because of this, and this, then that's what you tell the prosecutor and that's what you tell the court. The other thing you might do is spend an hour or two with a lawyer and just get charged for that time as to how you might represent yourself. And if you're going to have to represent yourself, give yourself a day in court, a month beforehand, so that you can see how it goes and how evidence is presented.
Okay, thank you for your call.
Thank you very much.
Helen in North Balwyn.
Oh, hi guys. Look, I have a question about significant tree registers,
Yes.
David. And if a tree is felled without permission that's on the register, do you know what the penalty is? I'm just finding it a bit confusing.
I don't know. You're in Burundara?
Yeah.
I can't tell you what the penalty is, but I've been involved in a case for one for Yarra, and the answer is it's thousands of dollars.
Okay. Is it the penalty units process, or is
but there will be a local law.
Yeah.
And there will be a possibility of an infringement notice, and there will be an offence as well. If it's a significant tree, you should expect a prosecution. And if you look at the local laws on the Boroondara website, you can actually get some idea of the penalty.
Okay. Thank you.
And John's called in about council responsibility for maintenance of a service road. John?
Yes, good morning.
Hi.
Just to put you in the picture, we live in Callista. We're on the main road. We're one of 5 houses that are accessed via a service road. I mean, the further you go along the service road, the higher you go versus the main road.
Yep.
We're the last house. The first 2 houses are accessed pretty much at road level. Houses 3, 4 and 5 rely entirely on this service road. We've lived here for 35 plus years. It has always been maintained, potholed, fixed, stuff like that by initially Sherbrooke Shire, subsequently Yarra Rangers. We and our neighbours have called on them to come and fix the potholes. There's always a lot of resistance. Oh, it's Vic Roads, it's not us, it's this. They have in the past maintained it, filled the potholes, graded it, fixed up the little guardrails. For the last year, we've been battling with them, saying, come and do it. No, we've changed the overlay. We're not responsible for that anymore. It's your access road. It's your responsibility. And yes, if we have done it in the past, it's been a mistake. But it's your responsibility, and we don't have the money to do it. Now, they've changed somehow, I guess, in pursuit of ever-increasing cost or decreasing cost budgets.
John, I'll have a look for next week.
Yeah.
But there's a piece of legislation called the Road Management Act.
Yep.
And it basically allows council to determine how, where and when they will spend their money.
Yep.
And they only maintain their roads to the level that they want, which isn't the level that you might consider appropriate.
I've got a text message here that says there is no definition of what is a tree in the Victorian planning scheme.
I beg your pardon?
I've got a text message here saying there is no definition of what is a tree on the Victorian planning scheme.
That's quite possibly right, but the local laws and the planning scheme don't quite work together.
Can't identify a tree.
Yep.
We put it to them that they've agreed to do it. They've created a precedent.
No, I turn it around another way, John. I accept that the service road is theirs.
Yeah.
That doesn't mean that they're required to maintain it to the standard that you want.
Or to any standard.
It's a question of the Road Management Act and their plans.
Okay.
So and the Road Management Act came out of some came out of a case where somebody tripped over a tree root on a running path.
Yeah.
And the question was, well, whose fault was it? What does a council actually need to do? And then there's this interesting distinction between non-feasance and misfeasance. Misfeasance is doing something wrong. Non-feasance is simply allowing a situation to continue.
Right.
And it's a concept that arises from people falling off the top of a stagecoach because the trees were too low. All right? So I'll have a look for next week.
All right.
But I think that your problem will be they've got a finite amount of money that they determine how it's spent, not you.
Yes.
Okay?
Yep.
Sorry.
Okay, I think most of it is just whichever the conversation goes, all of their responses is we don't want to do it, we're just going to find new and different ways to justify not doing it.
Well, it could be right.
Okay, we'll tune in next week.
John,
Thanks,
you're
John.
just keeping upbeat about it. I'm impressed by that. Bob from Croydon has called in. Bob?
Yeah, hi. David, Patricia, I'll be very quick. My partner was assaulted. She was seriously injured. The guy that assaulted her was charged, but when it came to court, the prosecution withdrew all the charges against him, and we don't know why. Just wondering, where do I go to or what would be the chain of
my complaint would be to IBAC. It's not that they dropped the charges, it's that they dropped the charges without giving you an explanation that you had the ability to assess.
Okay.
All right, so your issue is my partner or your partner makes the claim. I was injured as a result of what I say was an assault by X on this particular day. First indication was charged. The charges were dropped when we went to court.
Yes.
And I have no understanding as to why.
Yep. Okay.
All right, so it wasn't even as if they said this person should be subject to a diversion order, which requires a payment to a fund and generally a letter of apology. So none of that happened, or appears to have happened.
That's right.
Why were they dropped?
Yeah, exactly.
So to IBAC, and what's the IBAC process like?
Well, IBAC is there's a huge discussion at the moment as to whether there ought to be, because most of the complaints made against by police that go to IBAC come back to the VicPol for investigation, and that's an incredible point of frustration.
Of course.
Yeah.
All right.
Yes, well, the informant wasn't in court that day, and
so why did you attend? Were you required to attend? Was your partner to attend as a witness?
We were not asked to attend. No, but
there you go.
I went along to find out what happened, because at the first mention, he said he was going to contest it. And this was the contest hearing, I thought. But, we weren't called as witnesses. But
which would have made me mildly suspicious. If your partner is the victim, whose evidence would be crucial to a prosecution, and doesn't even get called, I'd be a bit twitchy, so I'd like to know why.
Yeah,
and that's the process you start.
Okay, thank you very much.
IBAC, off to IBAC for you. Just going to sneak one more in, because Tony from Bacchus Marsh has been incredibly patient waiting and has a question I think that lots of people would be interested in relation to superannuation. Tony, what's your question?
Good day. Thank you very much for taking the call. My wife and I are second-time rounders, and we both have industry super, and we're keen to be able to retire a bit early and enjoy our latter years. And we want to find out about having the super paid into a fund that it guarantees the income for whichever one of us lives the longest, but then goes back to our respective kids from our first-time marriages.
Yes.
And we seem to be getting... I've spoken to the solicitor who did our wills.
Yep.
And could not understand what we need to set up to allow the super to go into some sort of fund that then goes back to our own kids later on. Like a tenants in common.
Well, now, hang on. Why would you not simply maintain two funds? So that there's a fund, Tony, you have your fund that says if I die, I want a pension for my wife, and upon her death, I want what's left in the fund to go to my children.
Is that what I need to ask for?
Yeah, so your problem is you're trying to pool the money and then unpool the money.
Well, we're happy to have it separate. My understanding of the advice from the super fund was that if I die first, and I have significantly more super than my wife, but if we want to retire early, we obviously need to have an income to live on, regardless of which one of us is living.
Yes.
And the part that I couldn't follow or couldn't get a straight answer to my understanding was the part where if I die, then does my will enact, which would leave my wife potentially with not enough income.
No, well, you're okay. I think I can see the problem. I'll ask some questions too. So I've now got two lots of homework. Tony, your question, as I see your question, is that it's quite possible that if your wife gets the pension on your death, you get a pension for now, she gets a pension when you die. Does the pension that she gets give her the right to pull all the money out? Because your children would be eligible to receive a nomination from her. So the real question is whether you can lock down the capital to some extent in the pension arrangements in that period. All right?
All right, we snuck you in there. Thank you, Tony. And thank you, David. Bit of homework. 2 lots, right?
Yeah, 2 lots, yes.
Taking it on notice.
I will.
Thank you for your time. David Whiting there. He's a Melbourne solicitor taking your legal calls, and I think we got through quite a few there. This is ABC Radio Melbourne. Patricia Carvelis filling in for Jon Faine.